Chairman, if it pleases you and the committee, I would love for the Chief Judge from the Geechee Circuit, Judge Gates P., to join me.
We'd love for him to come on up. Did I pronounce your name right there?
Gates P.
Gates is the first name.
Yes.
Right.
P on there. Okay,
Yes, sir.
I apologize. How do you spell it?
Last name, P is in Paul, D is in dog.
I apologize for that. That's the first time I've ever messed up my life. Today in the week.
I was thinking that same thing, Mr. Chairman. I've known you a long time. Never known you to make an error before.
Absolutely. Well, I apologize. That was good to have you. Mr. Leader, why don't you tell us about House Bill 1003?
I'd love to, Mr. Chairman. Mr. Chairman, members of the committee, thank you for your time today. We're bringing you a bill that will add an additional judge to the Geechee Superior Court Circuit. That circuit is in southeast Georgia. It covers Effingham County, my home county, and Chairman Hitchens' home county, Bullock County, represented by my esteemed colleague Chairman Tankersley over here, and I also represent part of Bullock County. That's Statesboro, Scriven County, Sylvania, Jenkins County, Millen, Georgia. A little bit about the demographics and why this need and why the workload has grown so in that circuit. Effingham County, my home county, is one of the fastest growing counties in the state, in the top 20 in the nation. So we're a bedroom community for Savannah, and so we are experiencing very fast growth in every sense of that word. Of course, Statesboro, Bullock County is home of Georgia Southern University, and a very fast-growing community on its own right. And when you take the university out, it's still very fast-growing in every sense of that word as well there too. I'm very aware, knowing Judge Pede and his colleagues on the bench in the Geechee Circuit, I certainly understand how their workload has really been dramatically increasing over the last few years, and certainly understand the need for prudent and efficient justice in a timely manner. So that speaks to the need for what we're asking you for here this session. And of course, I think all of you know the Judicial Council of Georgia certified last year, due to the circuit's workload, it does qualify for additional judgeship, and I think it was ranked number one by that council. Now to Judge Pede, he's very eminently qualified and has done a great job over a number of years as that circuit workload has grown, as a number of judges in that circuit have grown, and he currently serves, as I said, as the chief judge of the Geechee Circuit. At this time, I'll be glad to answer a question, but I think it'd be important now that y'all hear from Judge Pede about his activity in the circuit and his take on what we need to do here to make sure that we can serve this. And you know, and I'll also add, if he doesn't know the answer to y'all's questions, as usual with our business, I'll be glad to make up one and answer that question if we need to. So, Mr. Chairman, if it pleases the committee and you, Judge Pede.
Judge,
Thank you, John.
how are you today?
Good to be here.
How long have you been on the bench?
20 years.
20 years. You've done this once before, right?
No, sir. Haven't done this once before, but
Not before a committee hearing.
1995 was the last time that we in the circuit got a new judge,
Okay.
and that was 24, 25 years ago. That was, at that time, I was solicitor of the state court, and subsequent to that, judge of that court, but have been on the Superior Court bench since 2001. I think John hit at the crux of the matter, is that our workload assessment in the Geechee Circuit is the highest of any of the 49 circuits in Georgia. The workload assessment is 1.51, which means that each one of our judges do a judge and a half's work.
And that
The
was reflected in the Supreme Court's annual report that they give to us.
Yes, sir.
Help with the caseload count.
Yes, sir. The caseload, and that's a bit of a misnomer, in that the caseload numbers basically are used to yield a workload assessment. And that workload assessment, again, is 1.51. Our circuit has experienced tremendous growth in number of cases, in the complexity of cases, as well as increase in population, increase in the student population of Georgia Southern. We're uniquely situated in that we have I-16 and I-95 running through our circuit, as well as International Airport in Savannah, which brings all kinds of judicial activity in our area. We have the support of all of the delegation. We have the support of all of our local county officials, all the sheriffs, all the county commissions, and we would appreciate your favorable view of this bill. I'd be glad to answer any questions that you might have. If I were to continue, it would simply be a rehash of what's been said.
Okay, Judge, thank you so much. Questions? Members of the committee for the majority leader or the judge. Is that you, Mr. Starr?
Yep. Thank you, Mr. Chair. And I'm a practicing litigator, so I understand the work that y'all do, and I appreciate it. And I'm very supportive of this. I just had a question on what you do with bail hearings. I'm trying to understand that in different parts of the state. Do you have magistrates that handle that for you?
We do not.
So one of you four have to kind of be on call?
One of us three.
Three.
Correct. Yes. Every bond hearing that's held in Superior Court is held by a Superior Court judge.
Okay. So this would help not only your workload, but would help administer justice faster too, right?
Yes.
Thank you.
Yes.
Okay, Ms. Oliver, is that you?
I'm happy to support this. Do y'all, have y'all created a separate juvenile court yet?
We have. And that juvenile court's been in operation now it began July 1 of 19. And these workload assessment numbers does not take into account any juvenile workload.
That's what I was assuming.
Yeah.
Thank you.
Sure.
And thanks to Representative Oliver, she was a champion for the juvenile court, and we spoke many times about our need for a juvenile court in the Geechee
okay,
Circuit.
good.
Thank you for
Thank
your
you.
advocacy on that.
Other questions from any members of the committee? Do we have anybody else signed up then to speak to this bill? We do not. Okay. All righty then. We have, is that you, Mr. Wells? Very well.
Move to pass.
There's a motion to pass. Is there a second? There's a motion and a second. Any discussion? Hearing none. All those in favor to pass House Bill 1003, please indicate by saying aye. Aye. Any opposed? You're off the rules, Ms. Williams. Congratulations.
Thank you, Mr. Chairman and members. We really appreciate this. Thank you. Thanks for your time.
Thank you. Good to be here.
Chairman, Restoration, you have two. Yes, on the calendar today. Do you have?
968, please.
968. Okay. You want to stay there or you want to come around here, Mr. Chairman?
Thank you. It's all right if Mr. Lewis joins me. Chairman Swim,
Yeah, absolutely.
come on up. Sit with me. All right. Now, see. Well, thank you, Mr. Chairman, members of the committee. I bring before you today House Bill 968. We have a substitute, LC 412386S, which is before you. Just a very tiny change from the bills introduced. I have with me today Mr. Jeffrey Lewis, who's a partner at the firm of Arnold, Golden, and Gregory. And the bill that's before you today is a result of a Court of Appeals opinion from October 31st, Halloween of last year, where the court held that the statute of repose should be applied to contractual warranties. That case was Southern States versus Tampa Tank. There's also an article that has been handed out from Clark Howard, comments that were made by Clark Howard. But in this case, the Court of Appeals held that the statute is unambiguous and makes no distinction amongst claims surrounding negligence, and those in contract. And therefore, the effect is that the 8-year statute of repose applies irrespective of the, an example would be if a 20-year warranty, say, was agreed upon, that the statute of repose would only make that effective for 8 years. And so as you might imagine, that could really harm consumers because they're under the expectation that they would have a greater period of time in which to enforce an agreement that was made previously. And due to this opinion, that's not available to them from this appellate review of statute. The substitute is only just a technical change on line 33. Originally, this act shall apply to causes of action which have accrued on and after January 1st, 1968. We just changed that to or, and so that's the only change from the bills introduced.
You literally changed an and to an or.
And to an or, yes, sir.
All right.
Well, we are in judiciary, right?
That's correct.
So at this point in time, I'd like to turn it over to Mr. Lewis, Mr. Chairman, if that would be all right, and he can
Absolutely.
provide some of the history here and answer any questions. Thank you.
Absolutely.
Thank you
Mr.
very
Lewis,
much.
tell us a little about yourself.
Well, I'm a litigator with the firm of Arnold Golden Gregory here in Atlanta. I do business litigation, and my involvement with this matter has to do with the representation of the appellant in that case that went to the Court of Appeals. My client was attempting to enforce a warranty longer than 8 years on a renovation project, and the Court of Appeals has held that the warranty, which in my client's case was for 45 or 43 years, was cut off at 8 years. So this ruling, if it stands, if it's not clarified, in other words, would terminate at 8 years any construction warranty on any structure in this state at 8 years. It doesn't matter how long the contract is for. By operation of law, that warranty would be limited to 8 years.
So my wife and I have a 25-year warranty on our roof, and I thought I had one until this ruling. Is that
Well,
correct?
under this ruling, your warranty is only 8 years, and if the 8 years have run, then it's terminated right now. Your warranty is dead, and the contractor is not on the hook for the other 20 or 17 years of that 25-year warranty.
Sounds like something that we ought to work on.
I agree, and I think you've all got the commentary from Clark Howard. There's probably no better consumer advocate in the state of Georgia than Clark Howard, and he became aware of this case, and he did this commentary back in December talking about how damaging this ruling could be and suggesting that the legislature fix it when y'all got back into session now.
You want to share that with us?
I'd be delighted to.
Sure.
This is a Clark Howard radio commentary on Southern States versus Tampa Tank, WSB Radio, December 4, 2019. There's a recent ruling by the Georgia Court of Appeals which has such a big effect on you and me as homeowners. It allows any organization we do business with, this is concerning your home, or if you live in a condo or whatever, to welsh on any warranty they've given you on the work they've done once a certain period of time has passed. That's his word. So let's say you have a roof installed at your home and it comes with a 20-year warranty. The Georgia Court of Appeals ruled that under the law as they interpreted it, doesn't matter that they've given you that long warranty. They can just shrug their shoulders and walk away, typically after no more than 8 years. This is unbelievable. It's so anti-consumer and shocks me. Now the reality is it's up to the state legislature when they come back next month to fix this. Because if you and I as consumers spend big money on our home, we expect that the work that we've done is going to be protected by warranty coverage. And then the company that gave us the warranty can say, well, in Georgia, even though we said we're going to warrant it for so long, we don't have to. That is a stunner, and I don't understand how the Court of Appeals made the decision they did. The legislature needs to fix it.
All righty. Questions from the committee members? From the chairman who would never welch to us, that is Chairman Andy Welch.
I'll note for the record that's a CH at the end of my name. Why the retroactive date in Section 2, line 33? It's a 52-year retroactive application. Why?
to clarify that it was the intention of the General Assembly back in 1968 that the application of this statute be limited to tort claims and that it not apply to contractual warranties. And so without that clarification, if this amendment were to be prospective only, then every warranty in this state that's over 8 years old right now would be void and cannot be revived.
Can we retroactively alter the law in this respect, and can we, in doing so, are we not interfering with contractual rights as they were understood at the time?
Well, no, I think what you would be doing here, again, is clarification more than anything else, because
Well, I mean, you said we're going to go back into the minds of legislators in 1968, which I wasn't even a glimmer in my parents' eyes. So.
well, I was around back then, and I know what they meant. No, that's only a joke. The fact is, there was no...
My parents or the legislature?
There was no need for clarification until this decision came down from our Court of Appeals. Up until now, both the Georgia Supreme Court and the Georgia Court of Appeals had interpreted the statute proposed to not apply to contractual warranties. So it's this recent ruling that came down on Halloween of last year that requires the clarification. And it is perfectly legal to do so under a ruling from the Georgia Supreme Court, which came down in 1999, Justice Benham, where the issue was a retroactive change to the statute of limitations for suit on a promissory note. And what Judge Benham said in that opinion was, it's well within the authority of the General Assembly to make a bill be retroactive as long as they say so clearly in the language of the bill. And that's why this bill has got Section 2 making it applicable to any causes of action that have accrued on or after January 1 of 1968.
And if I may, if we don't do that, we throw into question whether or not anybody with a current warranty that they thought was a warranty, if they have one or not, correct?
Well, that's right. Any building owner in this state, and it's any kind of building, farmhouse, industrial, single-family residence, public buildings are also fall into statute. Any warranty that's now more than 8 years old is void under this ruling from the Court of Appeals.
Please.
One last point I wanted to raise with you is would it not be a fair presumption to make that everyone that a business that has warranted their product for 20 years or 10 years or any time beyond 8, that they included the cost of repairs to the warranties in the purchase price, so that we as consumers purchase that knowing and understanding that the product we were purchasing would be warranted for 20 years, and we paid for that, and that's part of the purchase price, part of what we purchased, as part of the consideration for the choosing of that particular material versus some other product that may be on the market.
That's absolutely correct. And you can look at GAF Corporation. They make roof shingles. And if you buy their most expensive roof shingles, they will warranty the installation of those shingles for 25 years. And they charge more for their shingles because of the value of that warranty. And homeowners pay more for it. They want to have the security of knowing that if the roof leaks in the first 25 years, then the warrantor, GAF, has got to come in and fix it at no cost to the homeowner. So this is definitely part of the bargain. Any landowner who buys a warranty longer than 8 years, they're paying for those extra years. And so as a General Assembly, really as the people of the state of Georgia, as a matter of public policy, we need to enforce those warranties as they are written.
Okay.
That's all.
Ms. Oliver, are you 13?
Yes, sir.
Okay.
Did you seek review of the Supreme Court?
We have. We filed a petition for writ of certiorari.
Is it still
Eh,
pending?
It is still pending. It has not yet been ruled on.
We're interfering with ongoing litigation, which I'm happy to do in this case. I'm just thinking
Well-
that's usually something we think
We'll-
about.
I wouldn't call it interference. I would call it clarification. There was no need for this bill until this case came along, where for the first time an appellate court in Georgia said the statute proposed was intended to apply to contractual warranties. So the issue is much bigger than just this case.
I'm for you. I just want to know that we're doing that.
Yes.
It would. I think Ms. Oliver raises a question that we do talk about here a lot. And there are occasions when we change that effective date not to do that. However, as Chairman Welch and I were just talking offline here, if we don't, we leave another year potentially
I-
of people with warranties out there. Yeah.
I'm with you,
Yeah.
but
But recognizing it is appropriate thing to do here because we do talk about that, and you're good to bring it up for us.
thank you.
Yeah.
Right, and again, from the perspective of the Supreme Court, this type of legislation has been approved in the McNeil Construction versus Wilson case.
All righty. Who is number 12 down there? Okay, Representative.
Thank you, Chair. I just want to say I'm a family friend of the Bragmans, and I just want to give my condolences about Karen Bragman. And
Thank you.
She's an amazing attorney, amazing person.
Thank you. She was a great loss to our firm and to our community.
Yeah. And thank you so much for your hard work on this case. As a trial attorney, many of us here, we know how hard this is, and thank you for bringing us to our attention.
Thank you, sir. Thank you.
All righty. Any other members of the committee have a question for Chairman Efstration or Mr. Lewis? If there are not, I know we have a couple of other people signed up that would like to speak. Mr. Lewis, if you would just move one chair over, and Chairman Efstration, you can stay there if you want to. Bert Locke? Mr. Locke, come on up. Good to have you today. Appreciate you coming. Tell us your name and tell us who you're with, and we'd be happy to hear from you. Did I get that right, Locke?
Yes, sir.
Okay,
Thank
good.
you. Bert Locke. I represent today the Building Owners and Managers Association, a predominantly commercial, office, industrial, and medical office professional association. Our purpose here today is in full support of the clarification language. As you can appreciate, in a commercial environment, considerable amount of building equipment, building envelope is contracted for extended term warranties, elevators, and matters of life safety. So it's critical for us to ensure that those contracted extended warranties are preserved and not limited to the 8 years that became established in this judgment.
Okay, good. Thank you. We appreciate you coming. Any questions from the committee members for Mr. Locke? All righty. Thank you so much for coming today.
Thank you, sir.
We appreciate that. Yes, Chairman Efstration, we do not have anybody else signed up. So unless there's any further questions at this point from committee members, the chair will entertain a motion.
Motion to pass.
There's a motion to pass and a second. Is there any discussion? And that will be on the substitute that we have before us, LC 412386S. Is that correct?
Yes, sir.
Okay. All right. All those in favor, please indicate by saying aye.
Aye.
Any opposed? Passes unanimously to rules. Mr. Lewis, thank you for bringing this to our attention. We appreciate that.
Thank you, sir.
All right. And I'll go home and tell my wife that I was right when I interpreted my roof contract that I had earlier. So
Will you tell my wife that I was right?
I will. We'll help each other there. Yeah, absolutely. All right. Chairman Administration, you have one other bill for us today. House Bill HB 969.
Thank you, Mr. Chairman. So I'll present House Bill 969 as introduced, LC 364261 at this time. Sorry, if I could just get my notes real quick.
There were no speakers signed up.
All right, thank you, Mr. Chairman. The Georgia Commission for Equal Opportunity brought this bill to my attention, and it concerns the Fair Housing Assistance Program certification with the U.S. Department of Housing and Urban Development. The certification was lost by the state of Georgia in 2012, and since that time and recently, the Department of Housing and Urban Development has conducted a legal review of Georgia's fair housing law, and the state has sought interim certification. HUD determined that the existing law is not substantially equivalent to the Federal Fair Housing Act, and this was because of errors and omissions in our existing law, procedural deficiencies, typographical errors, and other issues. So House Bill 969 is brought for the purpose of addressing those problems so that we can be in compliance. And in fact, Georgia is required by our own law to be in compliance with it, and that is OCGA 8-3-2069, which provides that the administrator shall maintain with the with the United States Department of Housing and Urban Development status as a certified agency under Section 810 of the Civil Rights Act of 1968. And so this legislation is really intended as a procedural cleanup measure to address those certification issues. It is not a substantive change in law otherwise, but it would allow for simply for the procedure with which discrimination claims could be brought. It does not, I'll repeat, expand the existence of existing law outside of what was previously passed by the General Assembly. I'm happy to answer any questions. I know that the State Commission for Equal Opportunity also has representatives here. There are also attorneys here from the Attorney General's office who can answer any specific questions that any members of the committee might have. I'd be happy to answer any questions.
All right, we do have, Mr. Chairman, some questions for you. Number 6, is that you, Mr. Wilson?
Thank you, Mr. Chairman. Can you just go back and tell me that code section again?
Yes.
You said that requires us to be in compliance.
8-3-206, subsection 9.
And that this brings us in compliance with HUD requirements on.
So it would allow for, we expect it would address the HUD certification issue so that we would be certified by HUD.
Chairman Welch?
Thank you, Mr. Chairman. Chairman Administration, I have a question for you on line, get back to it, 122. The added language here says that the court cost only if the respondent prevails on all alleged violations of the article. So this court cost and attorney's fees would only be awarded under the circumstance where they prevailed on all of their claims as opposed to just a portion of them. Is that correct?
Yes, sir. And upon the other condition there showing that it's frivolous and the rest, yeah.
No other questions.
Okay. Number 12, Mr. Walensky.
Thank you, Chair. From a procedural standpoint, lines 180 through 185, why is there other discovery that's available, or why are we removing this code section regarding discovery? Are these lines?
I don't know if there isn't a witness here who can answer that. I would be happy to get that information to you. Should the bill move forward, I'd be happy to get that info to you before it gets to the floor.
Great, Chair. Thank you.
Thanks.
Mr. Chairman,
Yeah.
if I may.
Yeah, come on forward if you'd like to. There you go.
And Mr. Chairman, this is Jeff Stump and Dan Walsh, 2 attorneys in our environmental section.
Okay, great. With AG's office.
Yes.
Okay. Come on up, and if you'd like to sit down, that's fine. And there's a microphone right in front of that chair that you're about to sit in. Introduce yourself, and we'd be happy to hear from you.
Yes, hi, my name is Jeff Stump with the Attorney General's office. And GCO is one of my client agencies, and the reason that particular language was taken out is because the Administrative Procedure Act already provides for discovery, so it was just taking out duplicative language.
Superfluous.
Yes.
Okay. All right. Mr.
Great.
Walensky?
Thank you. Thank you.
Okay. And sir, tell us who you are.
I'm Daniel Walsh. I'm also with the Attorney General's office.
Okay, good. Appreciate y'all coming today.
Thank you, sir.
Any other questions from members of the committee for Chairman Administration or one of our 2 witnesses that we have with us today? And I do not think we have anybody else signed up at this point either. So if there are no further questions from the committee, is there a motion? Ms. Oliver moves do pass, seconded. Mr. Dryer, any discussion? Hearing none, all those in favor of passage of House Bill 969, please indicate by saying aye. Aye. Any opposed, same sign. Mr. Estration, you're off the rules with your second bill.
Thank you, Mr. Chairman.
That is all we have on our agenda today. Committee members, appreciate you being present. We're adjourned.
Very much.